Good morning, everybody, and West Coasters, good morning, good afternoon to everyone else. Hope you're all staying cool. It's kind of a sweltering day here in Maine, which is a bit of a rare event, but it is summer after all, so stop complaining, right? Well, welcome once again to our third webinar in the series 2013 IC Compliance and Engagement Enterprise Solutions Webinar Series, brought to you by MBO Partners Enterprise Solutions. We have a very informative webinar planned for you today, so I hope everybody enjoys. And we're still getting a lot of people enrolling as we speak, so I'll kind of drag out this introduction to get everybody in. Take a look at the right-hand corner. There's a section there for questions. So during the broadcast, if you do have questions, please enter them there. I'll try to address them during the webcast. Obviously, if time does not allow, certainly at the end of the broadcast, I will respond to any questions, or any of our panelists will, via email. The copy of the deck as well as the recording will be emailed to all registrants and will be available also on our website. And also, when you go to our website, hope you would take a look at signing up for our Contractor Engagement Quarterly Newsletter. Will be coming out in July. It's been very well received, and I guess we have almost 5,000 registered quarterly newsletter recipients, and we're getting some very positive feedback, so please sign up for that. So I think we've got our numbers. Let's see if we can't get ourselves started. So welcome to the Compliance Officer Training, the refresher course on IC qualification. So welcome. Let me start off by setting the ground rules here. Most everybody here are either in roles of a compliance officer, or you've been newly assigned as a compliance officer at your company. You'll be making independent contractor qualification determination decisions. Let's just say that you're the responsible party. You may or may not have enough skills and qualification to do the job, but it is your job, and now you're looking to get as familiar with this territory as possible. There's only one problem. You don't always know if you are making an accurate, defendable determination. So today, we brought a couple of experts in that do this every day, and they'll be providing you some handy information and real-life examples so you can kind of check your accuracy, see how you've been doing. If you're just getting started, we think you might be able to hit the ground running in your new role after this course. So let's start off by introducing our esteemed guests. First of all, my name is Jay Lash. I'm the Vice President of Market Strategies for MBO Partners Enterprise Solutions. Joining us today as well is Lonnie Goldman, an attorney who runs his own firm, Your Own GC. Lonnie acts as the General Counsel at Exponential Interactive today, and he has been responsible for IC compliance at a number of Silicon Valley technology companies, where he's got some unique hands-on experience in IC compliance determination, both from the client and a legal perspective, being a general counsel himself. And Lonnie has been an MBO supporter and has used MBO in some of his roles. So welcome, Lonnie.
Thank you very much, Jay.
Good to have you with us. Also, what we have here today is Dave Cassar, who is our Vice President of Operations at MBO Partners, but he's also leader of MBO's Vendor Advisory Service Team. Dave, maybe before we get started, people might be somewhat curious as to what the Vendor Advisory Service Team is. What does the VAST do?
Sure. Thank you, Jay. Hello, everyone. The VAST is actually an acronym for MBO's Vendor Advisory Services Team, and it's basically a team of highly trained MBO compliance officers who provide IC qualification advice to ICs referred from large enterprises, which are typically MBO's clients. So you notice I said advice. And the reason is over 25 years of providing these types of compliance services, we've learned, and you can imagine we've learned a lot, but we've learned that typically compliance processes can be fairly contentious and disruptive to our client's business. And it's primarily because the independent contractor or the IC feel that they're being judged by someone, usually a third party or the client legal department or a procurement department, as to whether they're a legitimate business, and they get either a pass or a fail grade. Well, these ICs are individuals who've been operating this way for years, and they're people who've taken the risk, stuck their necks out, invested some blood, sweat, and tears to get their business up and running. So having someone who doesn't really know them tell them they pass or fail as a legitimate business can be quite offensive, and this typically causes a lot of noise within the business. So those ICs who are connected at the highest levels of the client organization, you know, friends of the CEO, you can imagine the kind of noise that would cause.
Absolutely. Yeah,
so
just the worst people you want to get kind of aggravated at the beginning of a critical project.
Right. So from our experience, we've developed this approach that we educate instead of judge. And it's kind of a paradigm shift, but by providing clarity into the requirements to become a qualified vendor at a client, and then we help the IC by guiding them into a compliant engagement if it's possible. And if it's not, then we offer them other engagement alternatives. But we're seen more, and you could be seen more, I guess, as a compliance officer, as a consultative resource instead of as a dictator, if you will.
Yeah, it does sound like it could be a bit contentious to start things off, which obviously, as I said, isn't really the best way to start a project. So it sounds like there are a number of challenges for a compliance officer. So before we get into some of the details, let's talk a little about what those challenges are and how perhaps to overcome those challenges if you are going to be assigned to making your IC compliance and vetting determinations in your company. You know, I have to say this, that, you know, clearly there are a number of things that could make this a challenge. But Dave, what do you see typically in your role, because that's the focus of the VAST, what do you see as being some of the challenges a compliance officer has to deal with in your organization?
Sure. Well, I'll start with the contentiousness one. I think I alluded to it just a second ago, but setting clear expectations of what you're looking for when you are engaging in IC, or what your organization is looking for versus an employee. So really setting criteria that an IC needs to meet in order to be qualified to work at your firm in that capacity. And then
It might be things like insurance requirements. It might be things like the way you're structured as a business, some of the contract terms, things like that.
Absolutely. And I would align those criteria with you know, the regulatory tests, common law, economic realities, state ABC tests, and so on. But the point to take away from this, and the challenge that the compliance officer has, is that sharing these expectations only with the IC doesn't remove the contentiousness. Everyone involved in the relationship should be aware of what the goal is and where the target is, so that they're marching in the same direction. So share those expectations internally with the managers, with executives, with HR, and establish it as your company norm.
Great. Talk to me about that invisible risk. What's that?
Sure. Well, let's say an IC were to get hurt working on an engagement with your company. Are they covered? And if so, by what? Well, let's say they get injured while traveling or driving to your project, or while on your project. It's a different circumstance, wouldn't it be?
Yeah, exactly.
And then if an IC is a non-U.S. citizen working on your engagement, how are you covered then? Or what if an IC uses intellectual property of another organization in delivering your project and it becomes part of your deliverable? Who's liable for that? These are just scratching the surfaces of the risk associated with using independent contractors. But if you have a solid risk management plan, it's extremely valuable. It needs to align with your risk tolerance for your organization. And then you can have business insurances, or require your ICs to have business insurances to offset that risk or manage it appropriately. And then you know, decide who should be covered, you or the IC. You're covering the IC, they're covering their business, and so on. So that's key.
Lonnie, let's go to you for a second. As a lawyer, you've been in the role of a compliance officer, and I think you've said it to me before that as a client or as a company, you really don't want to be in the compliance business. But what is it about it that, talk to me about the challenges you see from the attorney perspective.
So as an attorney or as a compliance officer of any kind in a company, you're a little bit in the middle. That is to say, you want to ensure that the company is complying with law, but you're also understanding that the business needs people, and it's up to you to make sure that you're not an obstacle. You don't want to be seen as a hindrance to accomplishing the company's goals. And really, compliance risk is not something that business managers who desperately need bodies are really focused on. It's also hard as an employee of the company to always be objective. You'll always have senior people in the company coming to you and asking, well, can we make an exception in this case? So one of the reasons I like to bring in a third party is because you'll have that objectivity and they can help with some of the judgment calls with respect to compliance. It's not as black and white as you'd like it to be once you get into the details. There's case law, there's regulatory changes, different tests for state versus federal law, Department of Labor versus IRS standards. So interpretations and intentions figure in at every level.
Yeah, good point. So let's get into the thick of this. Let's talk about what it is, and I know many of you on the phone, on the call today are experienced compliance officers, so I'm not going to drill into, the heavy detail on what is an IC and what is not, but let's talk about what the IRS usually determines as a compliant independent contractor. And generally there are three categories or criteria: behavioral control, financial control, and the relationship of parties. So let's talk about the IRS version. Let's start just on a general definitional sort of basis. Dave, what does behavioral control really mean?
Sure. Well, just as it sounds, who's controlling how the work gets done? So an IC should be responsible for accomplishing the work and how they get that work completed. On the other hand, employees are instructed or managed by their boss or their employer on how to do their work. So I like to think of it as contractors are typically in charge of who, where, when, and how they perform the work.
Got it. Good. Lonnie, what's the financial control mean?
So financial control is about who's making the investment and whether the individual is getting paid regardless of the quality or outcome of the work. Where the client has the right to control all of the economic aspects, that looks more like an employment relationship. Where the contractor assumes financial risks, that looks more like a true IC situation.
Got it. Good. And again, using the IRS determination rules, this almost could look a little black and white. Dave, how about this last section, relationship of parties?
Sure. Yeah, then there's how the IC and the client have prearranged the relationship, but also in reality, in fact, how they're acting out that relationship. So do they intend on creating a client-contractor relationship, or do they intend, or does it end up being an employer-employee relationship? So the intent, I think Lonnie mentioned it earlier, is very important to both parties, but also having that intent well documented. And then is the relationship defined for one project or a limited period of time, or is it left open-ended? Obviously, an employee has an open-ended relationship with their employer. So those are the, some of the things that I would look for in that regard.
All right, let's kind of scratch the surface a little deeper now and go back through these, but maybe talk to this from your personal experiences, guys. Again, we have kind of mature compliance officers on the phone with us today, and they might like to hear some of your personal experience. So give us the real, what it typically contractors that are considered qualified look like? And Lonnie, we'll start with you when it comes to the behavioral aspects.
Sure. You see some of the highlights there, the notion of clearly defined deliverables in an SOW, that the client is not providing training, that the service requires a unique skill set. You'll see a lot of this on the front end. A lot of these, I won't read the entire list to you, but you'll see a lot of the issues kind of raised in the front end of a relationship. For example, if you see a company issuing its standard Lenovo ThinkPad to individuals as soon as they walk in the door, that's going to look more like an employee relationship. If instead you have consultants bringing in their own MacBook Pros, then that's an indication that some of the behavioral aspects are going to be more qualified as ICs. So one thing to think about is what are the day-to-day behavioral arrangements that you're going to look at with the individual from day one, because that's really when it starts.
Yeah. Now, you know, sometimes I get this question, hey, if the guy does the work off-site, he should be considered safe, right? Does that really matter?
Not necessarily, and as we're going to talk about in many different contexts, it's only one element, right? So what we'll see a little bit later is that if you meet one test, it doesn't mean that you're safe as an IC, and you have to take the entirety of the facts. So it helps if the person is not on site, right? You're more likely to be an independent contractor if you're not required to have face study like an employee typically would. But if you fail the test on every other aspect, you know, just sort of sending the person off one day a week isn't going to solve your problem.
Right, right. Yeah, and I think the comments that I get, and I've seen customers of ours get very very dictatorial when it comes to some of these things, like they can't get access to the facility, they can't use our equipment, or they can't use any access to our systems. You know, I think sometimes to get the work done, you need to. So once again, it isn't always black and white. I suppose it's a little easier to say, never come on site, never get access to our system. You're probably not an employee, but it doesn't mean one way or the other that you're going to be safe. So yeah, behavioral control is a big one. Probably the biggest of all three, looking more employee versus IC. Dave, what about financial risk? Anything from your experience to kind of share with people?
Yeah, sure. I guess as an IC, it's financial risk is different from an employee for that. At the basic level, if an employee shows up to work, then you have to pay them, regardless of their output or productivity. Yeah. I mean, you can fire them and stop paying them, but you can't stop paying them before you fire them. So right. On the other hand, with an IC, it's different. They have an opportunity for a profit or loss on each of their engagements. And there's a number of ways to determine this financial risk for an IC. The IC, they have to have made an investment into their business. Now, that's real easy if you're talking about an excavating company who bought their own bulldozer. Obviously, that's a big investment. But if you're talking about a management consultant that you've hired to do a study and provide you a report at the end of that, that paper that he prints the report on is not a significant financial investment. So some of the things that you would like to see are investments in his business, maybe through business insurances, or paying for his own travel to conduct the project through what he's billing you. He could float the project through extended payment terms, things like that where there's an investment. Another thing to look, Yeah,
go ahead. Finish up, Dave. I'm sorry.
Oh, that's all right. Yeah, another thing to look for is that there's risk associated with this, so profit or loss. And it's easier to kind of find a loss and tie that in here that he could potentially lose money or she. If they're performing the work on a not-to-exceed basis, or they are working to complete it within a certain deadline, and if they don't get it done, then they have to put in overtime and they have to eat that extra cost. A lot of the times we see clients scared to pay independent contractors on an hourly, daily, or monthly basis because it states in a couple different areas that milestone or delivery-based projects and payments are the most independent-like. But if you have clearly defined deliverables, using a billable hourly rate to come up with what a periodic invoice should equate to doesn't disqualify an IC from having risk.
Get it.
So keep that in mind.
Yeah, that's a good one. I think there's a couple of common concepts that I've heard from attorneys on this concept. One was that when it comes to expenses, have the independent contractor bill their expenses for the project into their fixed rate. So your reimbursement of expenses does look a lot more employee-like, and you could eliminate that. Plus, it puts a little bit more risk on the IC.
Very good practice.
The other one that I thought is kind of an interesting way to look at this investment is, did the individual have to purchase anything, not just insurance and business structural things, but some actual software to now be able to communicate, or if they're a designer and they have to design in a Mac environment versus a PC environment, or they have to use Quark as opposed to Apple product, they would buy that software. It's part of their business to do so. If you have to supply it to them, it's starting to, again, look a lot more employee-like.
Agree.
Yeah.
Another thing I guess would be, which is slightly different, is, let's see, employees are economically reliant on their employer for their income. But contractors have multiple revenue sources. So if a client project were to end, the contractor's business would continue on. And if the IC is reliant on the client for all or most of their income, they have risk should that client end the project. But if the IC has other revenue sources, their business is less impacted. So this is reverse of the other two examples that I gave, because this demonstrates that if the IC has risk, they are more independent, less employee-like. So, and the less risk the IC actually faces is a good indicator that the client does not, have financial control of the engagement or the IC's business.
Yeah. Dave, you bring up another good point, and I'll make sure everybody's aware. Once again, we're talking about the IRS compliance determination. Some of these things do vary by state, but I think the idea that if somebody doesn't complete the job, let's say a consultant doesn't complete the job correctly, but built into their agreement is some sort of warranty for the work, well, that's not very employee-like. That's very much like a business. That's good procurement practices to build that into their contract. The same thing with the multiple clients. A good procurement practice, if you're doing business with a vendor, is to make sure that that business is not solely dependent on you being their client. So this is no different than an IC.
Exactly.
Good. All right, Lonnie, let's wrap this up with this relationship of parties, which sometimes could be a little confusing. It does sort of become kind of a hodgepodge of the structure of the individual organization or the vendor IC, and a little bit more to do with the relationship between the company and the vendor. So explain this one through your experience a little bit.
Sure, and you see the list of some specific items there, but at the highest level, I think of the relationship question as being, is this an engagement between two well-established organizations, or is it not? And for example, on the notion of marketing services to the public, an employee is typically going to be dedicated to his or her employer, whereas a consultant is actually going to have at least a modest website. They're not hard to set up, and it is an indication that the person is interested in having at least a few clients, and is marketing themselves as being more than dedicated to one employer. You see some of the other points there related to the financial aspects. Right? A more legitimate business, quote unquote, is going to have a taxpayer ID rather than use an individual's personal Social Security number. Perhaps my favorite, because it's too often relied upon in a vacuum, is the last bullet you see on the slide, which is this notion that the contract between the company and the individual states that it's a contractor relationship. Well, you'll see this provision in pretty much any contract for services. Even a huge company that engages a major accounting firm will have in the engagement letter an acknowledgement that the companies are acting as independent contractors, not as joint ventures or partners. Well, that's obvious. There's obviously no independent contractor question when you engage Ernst & Young to do your auditing work. So throwing this clause into a contract is helpful, but it's not going to be enough. And so you have all these other factors that need to be considered to ensure that the individual is truly an independent contractor.
Mm. You're also reminding me of situations that I've seen with some of our clients who get very, very concerned about the multiple client relationships. So they start to think, oh my God, this independent contractor has been working with us and he's also sharing what he knows with my competitors. So they try to build in some sort of a no comp clause into their contract, try to look for some exclusivity where they can't work for any competitors. But that sounds very employee-like, right? Would you advise against that sort of contract clause?
Well, I'd be okay with that contract clause if you were interested in turning the person into an employee, which goes back to some of the original conversation that we had in this session, is that one of your biggest challenges as a compliance officer is that you're still trying to help the business and bring bodies on board, and sometimes hiring managers will be so hungry for a warm body or so desperate for one particular person, and that if they get really focused on, well, that person is going to insist on acting as a consultant, well, then is it really the right fit for the organization? That's part of the coaching that needs to take place. If you have executives saying, oh, we can't have that person working for our competitors, then you're probably trying to solve for a number that's less than 3 and greater than 7 to some extent.
Yeah.
And you really have to make some hard decisions, go left or right, as to what kind of a person you want, and maybe what you can help someone get coached into is the conclusion that, you know what, for this highly sensitive role, we actually do need a full-blown employee who's not going to work for anybody else. There's not going to be any question about their loyalties. We're going to give them stock options, we'll have equity in the company, et cetera, et cetera. So I'm glad you raised that, because it really does spawn some bigger, very important issues about the relationship.
Yeah. And that I think is real. That's the crux of this third criteria. Is if it truly is a business relationship, you're going to find easy ways to structure it and support it, and then ultimately document and determine that it is an IC. But if they're really not, you're going to have to struggle to kind of recreate the relationship that really should have been an employee relationship to begin with. So sometimes if it walks like a duck, right, quacks like a duck, probably the duck. So this is one of those examples. You need to look at it long and hard before you make that exception or change the rules a little bit. This IRS determination test, which is only one of the many tests that are out there, it can also almost sound a little black and white. But I think what we're seeing is it's far from that. There are a lot of innuendo and interpretation. There's a lot of differences that come into play based on the different job types in the company's business. So both the IRS and the Department of Labor have kind of gotten together with their own varieties of this test. The economic realities test, as David mentioned before. But one of the things that I try to mention to clients is that even if you've got that down pat, every state is throwing different curves at you based on laws that they've determined for their states might cover their particular interests. Massachusetts has different laws and variety of criteria that makes it really difficult for an individual who is working for a company in their core service offering. It used to be that Massachusetts allowed that, but now if you're a carpenter working for a construction company, Massachusetts law says you're an employee. California law has gotten so critical that there are fines and penalties. You literally have to post it on your website that you're hiring contractors, independent contractors, illegally, and thus not really creating a competitive environment, a level playing field. So it really is important that defend your qualification determinations in good documented evidence, proof that you could take to a judge if you had to, that if somebody was doing an audit, it would be easily traceable as to how and why you made the decisions you made. So that's maybe my little lesson learned there. All right, let's move on to what I consider to be one of the bigger questions that a compliance or compliance officer always has is, do I test all 1099 provided? If I'm going to write up a 1099 for a tax form for the income or the revenue that I generated for this business, do I have to conduct some kind of a compliance test? And are there exceptions, companies where I don't have to do a test? So again, being the lawyer, Lonnie, how would you look at the exceptions, or who to test and who not to test? Is there an easy way?
So there is some leeway on this, because you will see some really specific exceptions out there. There's an IRS publication that lists some pretty narrow job definitions that would be non-employees. In my experience, it's actually not very helpful. I've never worked at companies that have milk delivery people or some of the other random things that the IRS seems to be identifying. There is a common sense rule that certainly applies, and that if you've heard of the company and you know off the top of your head that it's large, and you can check on their website and see that they've got a dozen offices and hundreds of people, there's no real point in doing a lot of testing, particularly if you can get an indemnification in your agreement with them that they're taking responsibility for all of their individuals and paying taxes on them, and indemnifying you as the client for all that work. But I sort of challenge the notion of exceptions in many respects, because you just have a tough time explaining this to the business because it is so complicated. And as we saw in the previous slide, you've got different states, you've got different federal organizations, and every time you try to cite an exception in explaining something to someone, you'll have someone from the other org say, well, didn't you make an exception for Sally over in finance? And you have to explain, actually, I did not make an exception. I utilized an exception. It's very different.
Yeah.
And so you sort of you risk, even through the use of the notion of exceptions, you risk perpetuating the problem of a lot of one-offs and non-scalable carve-outs, where people are coming to you and say, can you make an exception in this case? And personally, my strategy on this has been, it's another way to utilize a third-party service provider, because they can not only provide the objectivity we talked about before, but you can use them to bounce ideas off of. We're about to engage this firm, for example. I take a quick look at their website. They look borderline. Do you think we should run them through our evaluation process at MBO? And good companies will give you an honest answer. They say, no, it looks established. I think the common sense rule applies here. Or they can say, well, we should probably run them through. So it's another reality check on some of the decisions that you're making, because it is pretty challenging to deal with the various quote-unquote exceptions.
Yeah, in fact, I once was asked, how large does a company have to be considered good enough to not test? And I had real difficulty answering that question in a black and white way. In fact, I said, well, generally the rule is 3 employees, so is it more than my wife and child that makes up my business? And do I have to actually employ other workers outside the family? That's the beginning of the determination. But then, volume, if it's a multi-million-dollar business, I suppose you could say you and your wife and child are all millionaires, but the chances are, you're not generating that kind of money with just 2 people engaged. I'd also take a look at the track record and whether or not you could identify that this individual or company has been in business for other clients before, has been paid, and ultimately has been a responsible corporate citizen paying their taxes, etc. So, yeah, you're right. A little bit of judgment involved, a little bit of common sense, not always just some rule of exception. But let's talk about misconceptions, because maybe that's one of those things that tends to happen in this role. People kind of hear from somebody else that, hey, if you do a determination on somebody and they pass the test, you never have to really check them. They pass once they're good. Or these online tests where you can fill out a form and it gives you a yes or no answer, I think all good. I think we know that it goes a little bit beyond that. It goes beyond things like term limits. If somebody's been on the job for 90 days, I think they're an employee. They're not a business. These are misconceptions that may actually give people more difficulty than clarity. Lonnie, anything that you've seen in your experience that are misconceptions out there?
I have, but you see this bullet pop up on the screen about issues outside the U.S. There's a preconceived notion that this is an American problem, but if you think back to where all of this ratification discussion comes from, it's simply from the government wanting to get its payroll taxes.
Yeah.
Well, you're not surprised to hear that every single government around the world wants to get payroll taxes. So all the governments around the world would much prefer to have people be employees than contractors. So remarkably, they all have very similar rules, and you'll see some different tests around the world, but this is an issue in practically every country that you might consider doing business in. I've seen it in Europe and in Asia, and you can expect that it would be an issue in any country where you're looking to get engineers, where you want to hire salespeople, where you're trying to expand in terms of product, in terms of R&D. It's a global issue today.
And what about job titles or roles? Is it all the same? A lawyer, programmer, Indian chief, or is it different for different roles?
It's different. You can't treat everyone the same. It depends on what they're doing, and it will go back to the tests that we discussed. It's not about titles or what is superficially on the contract.
So, Dave, what about the whole concept of an IC written up in a contract? Is that safe, or are we talking about another risk factor here?
Well, like Lonnie said, I think having IC and that's specified that this is a client-contractor engagement is a nice to have, although how the relationship is played out and in fact is key, and all the other elements are going to be taken into consideration when that federal or state auditor knocks on your door. So having that is a nice to have.
Yeah, and then, the qualification list that we had, I think if somebody doesn't pass one of those tests, there are some companies that play a pretty hard line rule and say, that's it, you're not an IC, you failed one criteria of the test. How misconceived is that?
Well, I think it'll depend on the situation, and each situation you have to look at the whole. What the intent was, what the agreement is, and what is actually taking place. So if you were to do that and rely on only one criteria all the time, or have one of those criteria not falling in your court and falling against you, I think you measure that and you weigh it and you make a decision based on that. You don't tie everything to one. It's just the opposite, and I wouldn't doubt if you have this on the screen too. If let's say you say if you incorporate, you can be an IC for our company. Well, that one cracks me up. I had an IC tell me once that he was able to incorporate in 20 minutes online. So just incorporating doesn't make you an IC. So, for example, I'm an FTE at MBO Partners. I'm a full-time employee here. If I were to incorporate with the state of Virginia as Dave Cassar LLC, and MBO starts sending me a check without withholding employer-side taxes, towards a 1099 that they're going to give me at the end of the year, and nothing else changes about my job. I come to the same office each day. I use the same computer and desk and telephone. This doesn't mean that I'm not an employee.
Mm. Yeah, clear. And it's good when you say it that way. I think a lot of companies have gotten used to bringing retirees back as independent contractors, and that's exactly what happens. They leave on a Friday after a retirement party, and on Monday they appear doing the same thing, but only as an independent contractor. You know, those are clearly and flagrantly abuses of the independent contractor rules and determination. And caution to all, 1099 and W-2 in the same year is a glaring red flag. And talk about red flags, I think the audits that people are fearful of, certainly with the IRS, you know, is something to worry about. But have we seen the IRS being the major auditors out there, Dave? Is this a common thing?
No, although it happens, but is it the only way that an audit can be triggered, or that your compliance program will be questioned? Absolutely not. You'll get complaints or legal actions filed by disgruntled workers seeking benefits, maybe business competitors regarding unfair business practices that could cause audits. There's target industries you might be operating within that are targeted by the IRS, or in certain states, interagency task forces look for certain industries. State agencies have, if one of your contractor files for unemployment with the state, big red flag, big audit flag.
In fact, I think that's probably the #1 trigger that we've seen, and I think our legal counsel has validated that the #1 reason for an audit usually comes from a state agency like state unemployment, finding that somebody, not necessarily in a malicious way, when asked at the unemployment office, who was your last employer, an IC can, very innocently say, well, my last client was XYZ company. They paid me, and they paid me on a 1099. And that isn't trying to get your company in trouble, but ultimately could lead to that internal or to that external audit.
I have actually personal experience with that, Jay and Dave, and that is, in fact, the way I've seen the misclassification issue come up is from one of those unemployment compensation claims that a former person affiliated with the company made. And just like you said, Jay, the form does not really instruct the individual very well. It doesn't ask the person, well, were you technically an employer, an independent contractor, or did your contract say you were an independent contractor? Right? It doesn't get into any of that. It just asks who was last paying you, basically.
Right.
So one of the things that you learn as a compliance officer is that the HR function, assuming that it owns contractors in the first place, needs to be pretty careful in the offboarding of those contractors. Make sure they understand that it's really inappropriate for them to be claiming unemployment based on the independent contractor engagement that they had with the company.
Really,
Absolutely.
You just brought up another great point. That's the whole concept of offboarding an independent contractor. I think a lot of companies spend a lot of time investing in the vetting and the inboarding or onboarding of a contractor, but how many actually take a follow-up step to debrief that individual, make sure that there's some form of knowledge transfer, turnover of documents, and as you said, some sort of coaching to make sure the individual recognizes their status and it doesn't take you to the unemployment office by error. So, yeah, good advice. Now let's take it to the next level, which I think ultimately is what everybody in this role probably fears, You've got a manager who really needs this worker. They say there's nobody on the planet that could do the job. Our business will fail if we don't bring this person on. My job's on the line, et cetera, and so on. But they don't qualify. And they miss it maybe by a mile. So, you know, you could say, well, at least I tried. I ran it through the test. I was watching my company's interest. But let's say bottom line is I've got a pretty upset business manager, maybe even the CEO who's upset. Now what do? What are my options? So, you know, the clear and obvious one is cancel the project and find somebody else. But sometimes that's not an option. You know, from your personal experience, and I know you've had to wrestle with this in your role, what are some of the other options you might have when you're dealing with a non-qualified IC?
So one of my personal favorites is to really partner with human resources, particularly with recruiting, and really holding recruiting accountable, right? The goal was to fill this position with someone who is qualified. Well, we didn't really find someone who was qualified, right, in all the necessary respects. And so we really need to check with our recruiters to see if there's someone else whose skills are really a match. And I challenge the recruiters on this front, and I hold HR accountable as well, because if HR is using recruiters that aren't really understanding our requirements and don't really follow the full scope of the specification, then we're not really well aligned, and we're struggling as an organization. So it's that kind of mutual accountability that leads me to suggest, well, I think we should consider some of the other resumes that we saw.
Yeah. Now, you could also take that person, right, and run them through one of your staffing firms.
Sure.
Dave, how does that work out?
Well, you could. Sometimes it's okay for the independent contractor. Other times they don't want the stigma or the status of being considered a temp worker. That's a reputation that if you have a big temp program inside the company, they don't want, and they don't want it externally either. Plus, if they're paid as a temp worker on the W-2, then they're unable to take advantages of kind of the reason they probably came independent in the first place, is self-employment tax and advantages and retirement benefits and the flexibility of doing things at their own time, at their own location, and their own way. So there's a lot of challenges with that.
I would say that probably one of the, and this is a common solution, of course, you send them to the payroll firm, they didn't pass the test, tell them they didn't pass the test. That always starts off things on the right foot. But then when they get to the temp agency, they realize they've lost a lot of the freedoms and flexibilities that they had being independent. In fact, it might provide them with the difficult tax filing that year if all their other clients were treating them as independent contractors. So it's and especially these high-level guys that are doing work for the CEO at $500 an hour and or $20,000 projects. We had a speaker who was brought on to do high-level coaching with the C-level of the company, and when they sent him to get through compliance, he was not only missing certain things, it was also found that he was an employee that same year of that company as a C-level and was drawing money as a board of directors, and it is a very complicated scenario. So payrolling seemed to be the best option, but that individual flatly rejected it, and fortunately MBO had a solution for them, so it was able to get done. But it's a very could be a dangerous situation for the relationship. We've also seen in some lighter cases, so to speak, especially with your vast service, Dave, that you're able to make some changes to become qualified. How does that work?
Sure. Well, let's say you are set up as an independent contractor, you have other clients, you're marketing to the public, you have an SOW with this particular client, it's on a firm fixed bid that you'll get paid for when the project's completed, everything's aligned, yet you don't have the insurance or the investment in your business. Well, we might, make a recommendation that you price some insurances now that you've met all the other qualifications. That might push you over the edge, get you qualified, and you can become a vendor of that client. That's a real simple example.
Yeah, got it. Yeah, and I think, setting up a website, making sure that you said you had other clients, is that documented? Could we see copies of those invoices? Things like that, building your case before you get too deep. One of the things that I've found in my experience is the best thing that can happen is that you're at the front end of this relationship and you could coach and document and do all the things necessary to make sure it goes off on the right foot. What do you do when the water's under the bridge and the relationship has already started? You don't get the call until it's time to cut a check.
Yeah.
What do you do with that one?
And another thing that we find, Jay, to tag on to that, if I may, is that we're not only educating and adjusting the relationship from an IC perspective, but also from the client manager who engaged this IC, and them understanding that this is a business-to-business relationship and I'm going to treat it that way. Then you're actually securing and shoring up this relationship for the long term.
Yep, good point. So you also have the option of using an independent contractor engagement specialist or an ISIS. MBO is an example of one. There are others out there, certainly none as qualified or as good as MBO. And Lonnie, might you add your personal reference to that?
Yeah, I mean, these are all sort of fine alternatives, but I've used the last one at a couple different companies now because it has simply worked the best. It allows the most flexibility for the service providers, and it protects the company in terms of compliance and also keeps the company moving forward in its business goals. So it's worked well for me, so I'm happy to provide that reference.
And Dave, I'm sure you're quick to recommend MBO as a solution.
Sure.
But maybe it's not right for everybody, and I want to be clear in stating this isn't just a commercial message. What's potentially one of the rationales for not going to MBO?
And maybe you have workers who who are probably better suited for a payroll type solution, that they're not set up as real businesses and they just assume be paid on an hourly basis with overtime and what have you. Then you probably should look to a different independent or a different provider.
In fact,
focuses in that area.
I think that's the key to the lockbox here. If you're if you're qualifying independent contractors erroneously and you've done so for years and you're trying to correct the situation, maybe the best solution is, if they're not really self-employable, there was an error historically, somebody made the decision it's going to save the company money if you pay them as independent contractors, not an uncommon rationale. Correct the problem. The payroll provider may be the ideal solution. I'll just reference that anybody could walk up to MBO, and a lot of people do, and say, hey, look, I'd like to go in through you, and you're my firm of record now. And we do that every day. In fact, that's the core and bulk of our business. But from an enterprise perspective, to say all your ICs go through MBO, that's a commitment that the company has to make to a program, to compliance in general, and maybe even to go one step further, it's probably a resource commitment as well. So the executives down have sponsored it, support it, and will provide you the resources necessary to engage an ISIS. So it isn't always the best solution, but I would say get there first. Hey, since I lost my little question screen here, Dave, are there any questions that came in that you see?
There is one,
okay.
And it says, can you speak more to the premise of services being core to the business? We all know the example that if you own a shoe store and you engage someone to sell shoes, those services are integral to purpose of the business, and the worker should be an employee. But with multi-level companies, corporations that have several product offers, purposes for being in business, how far down does core to business go? Great question.
Well, I give a real life example on this one, and then I'll let you address it, Lonnie. But there was an online internet provider, very well reputed, well known, one of the biggest in the field. Ended up with bloggers who were doing work for them as freelancers, and essentially the court determined that that's your business. You can't send out that work these people need to be treated as employees. They don't need to be all full-time, fully benefited employees, but don't try to get away with just paying them as freelancers on a 1099. So that company had to literally hire thousands of workers that were freelancers that were doing blogging on this internet provider. So that's core to the business, and it's clear when I've mentioned about the Massachusetts law. If you're providing construction services for a construction company, unless you can make a pretty good case for the fact that this is a one-off project kind of a deal, those carpenters, those roofers, and those cement pourers are probably your employees, and you need to treat them that way. So, structuring the relationship is very important, and also, making sure that you've done your due diligence, that the relationship of that business is truly a business relationship. So we've got 2 minutes here, so I'll ask for maybe some parting wisdom from our expert panelists here, and you guys have been great, and I appreciate all your insights. But if you're going to talk to a new compliance officer or somebody that's getting off in this role, what are some of the advice you might give them? Lonnie, how would you start them off?
Yeah, the two main pieces are one, try to learn as much as you can about the nuts and bolts. This is a very rich area, but there are white papers, there's resources on the MBO website, there are blogs, there's Twitter accounts that you can follow. The more informed you are about the details, the more effective you're going to be. The second bit of advice is to make sure you're partnering with some of the other key stakeholders. Whether it's legal, finance, or HR, those three functions are typically going to be three legs of the same stool, and they will be your allies in getting this done. There's a certain amount of mutual accountability that you need to strive for so that the organization is successful, but if you identify your allies in this regard and develop cohesive policy with them, you're more likely to be successful.
Great points. Good advice. Dave, how about you?
Two quick closing things, and these would be more for compliance officers who have a program or are looking to improve it. Keep updated IC files. Just because you passed that person 3 years ago doesn't mean that their relationship or behavior or projects haven't changed. Review them at least each new SOW or annually at a minimum. And then the second thing would be close the loopholes, the back doors, the ways the ICs and managers can go around your program. Make sure you're capturing people who are presenting a risk to your organization.
Yeah, good advice. I'll give my 1 minute closing advice to prevent some of that after the fact, water under the bridge, so to speak. Make sure the communication is clear to your line people, to your business people, that know that an independent contractor is a vendor and needs to go through a vetting process, that they shouldn't be setting up arrangements to get work done without consulting some sort of a centralized vetting function, whether it be your office, the compliance office, the accounts payable office, whatever it is. Somebody needs to be the responsible party, and it needs to be clearly communicated that that's the first step. So great advice. We are out of time. Thank you all
Jay,
for attending. Yeah, go ahead.
A question that keeps coming up is there any chance of the attendees getting a copy of the presentation?
Yes. In fact, what we're going to do is we will send a copy of the presentation along actually with a survey that we're going to be doing, asking for your input on other topics or things you would like to hear in future webinars, as well as they'll have access to the recorded webinar through our website, so you'll be able to get that. If anybody would like to contact me, Lonnie, or Dave, there are our addresses. And stay tuned. In 2 months, we will have the 4th series, an interesting webinar, A View from the Other Side, Meet the Independents. What is it like to see the work through the independent's eyes? What do they think is important? What do they value? We'll have some very successful independent contractors speaking through their experience about their clients. So you'll hear about what you need to do to be a client of choice for independent contractors. Thank you, everybody, for joining us, and we'll catch you next time.